This case is about a robbery, perjury, and making a false statement to the police. It's also a good demonstration on what happens when there are two statutes that seem to criminalize the same conduct. Which statute can you be prosecuted on, and which one should fall out of the case? Here's what happened in this case. The defendant approaches the victim's car and asks the driver and the victim in this case to use her cell phone. At first, she doesn't want to let him, but eventually she feels more comfortable when she gets the phone number. She lowers her window a little bit and says that she will dial the phone number for this defendant and then let him use the phone on speakerphone. So as she's doing all that, the defendant finally reaches in and grabs her phone, trying to steal it. As he's grabbing the phone, there's a struggle going on, but eventually he gets it and starts running away. Meantime, a good Samaritan drives by, sees what happens, and hears the victim yelling, so he decides to run after the defendant. He eventually catches up to the defendant, but he's met by more people who jump out of a Chrysler who start beating them up. So as the fight goes on, eventually the victim drives up to the scene, and so everyone disperses, including the defendant, and all the guys that were helping him out jump into the Chrysler and they flee. When the police officers finally arrive, they interview all the victims and they get the description of the Chrysler that fled the scene earlier. About the same time, they receive a computer-generated notice that the vehicle was stolen. So what they decide to do is interview the rightful owner of the vehicle. They arrive to this person's house, and what the person says initially is that he was at the fair, he got drunk, he got out in the parking lot and couldn't find his car, so he realized it was stolen. But the officers had video footage and surveillance footage of this vehicle, including the person that they were interviewing driving it only several hours ago, exactly where the robbery happened. So he had possession of the vehicle when the crime occurred. So when he was confronted with this information, he changed his story a little bit and said that the individuals in the car essentially kidnapped him and drove around with him in the vehicle, and that he didn't know that he was part of this robbery. Long story short, the owner of the vehicle gets convicted of robbery and making the false statement to the police. The jury finds that he was the one that committed these crimes. The defendant appeals and makes a number of arguments. First, he said that the jury could not convict him of robbery. Robbery is defined by Section 211 in California, and it says that it's a taking of somebody else's property by force or threat of force. And he says when he took the phone, he merely grabbed the phone and ran away with it. Now, it is true that mere taking something would not be robbery. It would be regular theft. It is that force or threat of force that makes it a crime of robbery. And in this case, the Court of Appeals says that there's sufficient evidence and that the jury found that he didn't only take the phone, but there was a struggle. And the victim did not want to let go of the phone at first, and only with that force was he able to take the phone away from her. Thus, he was probably convicted of robbery. Defendant's next argument is a little bit more interesting. Remember, he gets convicted of perjury under Section 118, which is making a false statement to the police under oath. What he says now is that he should have been convicted of a similar crime under Vehicular Code 10501, which is making a false statement about a vehicular theft. As you can see, these two statutes are very similar. Really, the only difference is that one is made under oath and the other one seems to apply to any false statement or reporting of vehicular theft. So the question is, which one applies in these set of circumstances? Under Williamson rule, If there's a general statute and a special statute, where the general statute encompasses all the conduct of the special statute, there's going to be an inference that the legislator intended for us to use the special statute when prosecuting an individual. How do we figure this out? First, we'll look at the elements of the crime. Does the general statute encompass all the elements of the special statute? And in this case, yes. In order to be convicted of perjury, you have to do everything that you would do under normal making a false report to the officer about vehicular theft, plus do it under oath. So that's really the only difference, is that under oath section. So yes, when you answer the first question, it does encompass the special statute. The second question is, when you look at the two statutes, if whenever somebody commits a crime of special statute, it would generally also mean that he just committed the general statute. Well, in that situation, we again say that the legislator must have intended for us to use the special statute. So the Court of Appeal agrees with this defendant and says that's correct. He should have been charged and convicted of the second statute, the vehicular code, and not the general perjury statute. If you enjoyed this video, please click like, subscribe, hit that bell notification button so when next time I post, you'll be first to know.